Hear ye, hear ye, hear ye. The Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case this morning is 2020-1574, Cynthia Claussen versus Heights Chiropractic Physicians, LLC, et al. For the appellant, Mr. Bischoff.
Good morning, Your Honors. As an initial matter, I'd like to reserve 5 minutes following Mr. Stanton's briefing for rebuttal. My name is Jake Bischoff, and our firm represents Heights Chiropractic, LLC, and also previously represented Dr. Donald Bissessi in the underlying lawsuit. I'm sure you all are well versed in the facts of this case, so I won't try to belabor any points, but I think there are a couple things points that bear mentioning in terms of the facts. Heights Chiropractic and Dr. Bissessi were originally named in this lawsuit. It was filed and they were served. However, following the initial filing, this case was dismissed, 41A, and then refiled. It is in that second refiling that the appellee failed to perfect service on Dr. Bissessi. And it was that failure of service that we ultimately sought dismissal of Mr. Bissessi and was successful. It was on that dismissal that Heights Chiropractic then moved for summary judgment, which the trial court granted, and then the second district overruled. Ultimately, we would ask this court to reverse the second district's order and reinstate the trial court's properly, in our opinion, properly granted summary judgment. As it pertains to this appeal, there's a couple points I want to make that are rooted in substance. First and foremost, I would note that in the plaintiff's appellee brief, they point out as a fact that Dr. Bissessi was a patient of Heights Chiropractic LLC. However, that is not the case. Heights Chiropractic LLC is not licensed to practice chiropractic medicine in the state of Ohio, nor can they be. Pursuant to the Ohio Revised Code and the Ohio Administrative Code, only a chiropractor can practice medicine.
Excuse me, but wasn't Dr. Bissessi an employee of Heights?
He was an employee of Heights. But I think that would lead me right into our application of worth, which we believe is paramount to this appeal. Worth stood for the proposition in the legal setting that because only individuals can practice law, only attorneys can practice law, a law firm cannot practice law. And therefore, when there are no identifiable individuals in the lawsuit in which primary liability can be predicated, then no secondary liability can follow vicariously to the law firm. So I think in this setting, as it pertains to our appeal, that's important to point out because like other physicians and attorneys, chiropractors have to be specifically licensed to practice chiropractics in the state of Ohio. And thus there is no patient-provider relationship between Heights Chiropractic LLC and Ms. Claussen. And so that goes right into what we believe is kind of the crux of this appeal, is that the holding of worth should be applied to this setting, and that because Dr. Bissessi, his liability has been substantively extinguished for failure to service, that the secondary liability of Heights Chiropractic through the theory of respondent superior should also be extinguished.
But didn't Worth say that a plaintiff may choose to proceed only against an employer?
I don't believe. I know the holding of worth specifically addressed. It didn't overturn the fundamental principles and standards of respondent superior liability in the state of Ohio. In that a plaintiff is free to choose under traditional theories to sue one or the other or both. But Worth, I think, recognizing that the underlying the focus of respondent superior liability is control, and in settings where a professional license is required in order to practice the application that the individual charged with practice is practicing, there is a lack of control, because only that individual is responsible and charged with performing to that standard of care.
It seems like in Worth, though, in citing Losito, the court was really more focused on the plaintiff. Once the plaintiff's judgment has been satisfied, if it's satisfied against the employer has third-party ability to go after the errant, in this case, doctor. And even in the middle of a lawsuit, the employer could have used Civil Rule 14A to pull back in that doctor. So I really don't see Worth working in the way that you want it to. And that case was just specifically limited to a law practice and attorneys. And I don't know, do you see differences between the two? I mean, you're talking about licensure, which makes them similar, but this doctor actually physically performed the move, the chiropractic move on her, which she claimed ruptured her implant. And with a law firm, you could have a paralegal making a mistake, you could have an associate making a mistake, or just even an administrative assistant missing a deadline, and you could have malpractice.
Well, I think most importantly, I do think Worth has a lot of bearing, because although Worth dealt with a legal setting, in reaching the decision in Worth, this court strongly analogized the practice of medicine, an analogy that I know has existed in the state of Ohio and many other states for decades. So I think that is a main point as to why Worth should be applied. And I think, too, a lot of district courts have correctly applied Worth, including the 1st District and the 8th District, to reach medical settings. So yeah, I think Worth.
Counsel, is there anything in Worth that specifically limits it to the set of facts which were a law office that or law practice? Is there any language that says this is limited to only law practice?
I don't believe so, and if there is, I think then I would urge this court to expand it to reach the practice of medicine, because I think that the practicalities and the realities of Worth and the logic and the reasoning this court used to get to its decision would hold regardless in the practice of medicine. And I would also note that the wording of Worth, specifically in the 2nd District, in overturning the trial court's granting a summary judgment, they limited the application of Worth to instances where the alleged employee is also a part owner. But the wording of Worth, that the certified question itself, specifically includes the word employees and also includes the word associates.
What's the difference between employees and associates?
Well, in this case, I don't think there would be. In most law firms, associates, as opposed to partners, would be considered employees. In the 2nd District said it doesn't reach employees; it only reaches part owners, because that was, in that case, in Worth, the attorney in question happened to be a part owner, and I believe the reference to him being a part owner was only mentioned tangentially and was not meant to be a fact of significance. And ultimately, I know the appellee argues this, and so does the Ohio Justice Association argues this in their opposition briefs, is that we are trying to establish new law, and I don't believe that's the case. I believe Worth is the controlling law, and for example, they cite the case Losito v. Cruz. I would note that Losito v. Cruz was a case established in 1940. And really stood for the fundamental principles and standards of respondent superior liability. Our position would be that Worth did not overturn or change those fundamental principles, but rather acknowledged that there are exceptions to the fundamental standards and principles in cases where there are a professional licensure in play, and that when the liability of the employee, in our case, a chiropractor, has been substantively and unequivocally extinguished, then there are there's no vicarious liability by means of respondent superior left for the employer. That being said, I will,
Well, who pays?
go ahead.
What happens if the employer pays for the malpractice insurance? Still, we do that?
Well, I think that's might be an issue that hasn't been raised or briefed, but I don't think it would. I don't think it would change the. I don't think it would change the analysis, because ultimately, in Worth, we believe the analysis focused on control and the ability of a legal entity to commit professional malpractice, and regardless of who pays the premiums, I don't think that would affect that analysis.
But you're saying essentially that if someone is so beholden to a corporation like your client, to the point that that they cannot practice outside of the work, for instance, the Heights, because their only malpractice insurance is held by the Heights, then if by some technical defect, such as a failure to perfect service because they served it at the wrong address, that there's no recourse then for an injured plaintiff.
Well, I think there still would be recourse, and I guess first, I don't believe that the.
Well, what would that be?
Well, there could be claims for direct liability, potential claims against the employer, and I think that there are pre-suit and post-suit discovery tools in place that could be used to work around any issues that were presented in hypotheticals, or in this case. In this case, it was ultimately just a failure to serve, which I believe that holds true in potentially any civil litigation.
No, we're talking about respondeat superior, which is long established law. And the way that you, with Losito, it doesn't matter that it was 1940. That just shows how long established that law is, and it goes back even before 1940. So you're asking for a major change in what the common law has been in this state.
Your Honor, I don't believe so. And I didn't, although it was cited in 1940, I didn't state that it was cited. It was a 1940 case to show that it should be overturned. I don't believe Losito should be overturned. I simply believe that Worth recognizes an exception to the standards and principles of traditional respondeat superior liability, and that Worth should be, that exception should be expanded into the field of chiropractic and medicine.
Thank you.
Thank you.
Good morning, Your Honors. Ms. Claussen was a client and a patient of Heights Chiropractic. She appeared at Heights Chiropractic to be treated. When she went there, she was treated by various employees of Heights Chiropractic, one of them being defendant in this case. She was then billed by Heights Chiropractic and paid the bill to Heights Chiropractic. She had never met this individual who treated her and injured her that day. What the appellant is asking for is for the court to go back and change at least 80-year-old set law regarding respondeat superior between an employer and an employee. No one disputes that the defendant chiropractor in this case was an employee of Heights Chiropractic. I believe Mr. Bischoff just mentioned and agreed to that earlier today. The law is clearly established, as the second district said, an employer-employee relationship. The plaintiff may sue the employer or the employee or both. It's the exact same thing. Yes, ma'am.
The question here. All right, I'm getting an echo. Anybody else getting an echo on this? Okay, never mind. No, I'm not. The ask here, the request is that we expand Worth. That's a simple, I guess, path that the appellant believes is a viable path in relationship to the liability of the chiropractic. The doctor was not properly served he is released from liability in the lawsuit, and then without proof that there was some kind of malpractice specifically by the chiropractic business, Worth would apply. And I think that's the argument here. So what's your best argument on why Worth should not be expanded to other professional organizations outside of a law firm, lawyer relationship?
Thank you. I believe, Your Honor, that as the second district found and as the seventh district has found, Worth did not involve an employer-employee relationship. It is wholly inapplicable to this situation where we do have an employer-employee relationship. In Worth, he was a part owner of the firm. He was not an employee.
Counselor, but when I read Worth, it doesn't make any distinction about employee, employer. In fact, it talks about it talks about associates. It talks about there's no reason to think other than that the person who was at issue at Worth was a part owner. There's no language except that suggests it only applies to part owners.
Well, Your Honor, the fact that
The answer to a certified question that was much broader than that.
Understood, Your Honor. I believe that in Worth, it is clear there's not an employee-employer relationship. There is here. As far as the appellant is.
But you don't disagree that Worth made clear that even if this person was an associate, it still would apply, right?
I believe it would apply. I believe that is clear. I think that Worth also states it's a narrow exception, which I would argue, and as the second and seventh district did, does not apply in a case such as this. The appellant has asked that this be applied then to all professionally licensed.
Excuse me, but it doesn't apply in a case such as this. It can't be because of the employer-employee distinction, because that wasn't at issue in Worth. It must be for some other reason, right?
You know, I think one of the main reasons it is distinguishable, which is our intention, one of the main reasons is because it does not apply to an employee. It does not involve that relationship.
But Worth, you just said, does apply to employees. So it's not the employee-employer distinction, because no one disputes that an associate that the holding in Worth would apply to an associate just as much as a partner, right?
I believe that is the language of Worth, Your Honor. I believe that's correct. Well, in this case, indistinguishable from Worth, the actual firm has other avenues of liability as well. There's an argument that was made that the company cannot practice chiropractic, cannot be a chiropractic doctor. They do control the means and the methods and other aspects of someone's employment as an employee, which is definitional for an employer-employee relationship, that there is control over some of the methods and the procedures and the means which the job is done. There are lots of other licensed employees in the state of Ohio, a lot of other professions that require licensure, funeral directors, cosmetologists, various other persons who require a degree but can still be employees and can still be subjected to that liability.
But those employees aren't in the malpractice statute, are they?
Your Honor,
You can't pursue. The legislature has not allowed you to pursue a malpractice claim against a cosmetologist, right?
I do not know for sure, Your Honor. I've never seen that.
That would be an interesting lawsuit. Look at my hair, maybe I have a claim. I'm not sure.
I don't have that problem, sir. But for that reason, Your Honor, we would urge the court not to disturb what is firmly settled law between employees and employers, and to uphold the second district's opinion, and which is also very much on point with the seventh district, which found in a very similar case in Taylor versus Belmont that the hospital still could be pursued, even though there was no pending case against a employee, doctor or nurse or other professional. And with that, I would conclude.
Thank you. Mr. Bischoff.
Ultimately, as it stands in the state of Ohio, there are inaccuracies and inconsistent rulings among the district courts with respect to worth. We believe that the language of worth and the logic of worth should apply across the board to the practice of medicine, including chiropractics, just like the first district in the
Counsel, if we agree with you and we expand it, where do we stop?
Well, I believe exactly where worth stopped itself. I don't think there's any reason to expand it any further than what worth did. In instances where there's a malpractice claim against a professionally licensed individual, and that claim has been unequivocally extinguished, then there can be no vicarious liability or through the theory of respondent superior upon the employer, in this case, a chiropractic clinic.
Is this just a benefit to professional licensed individuals, entities, to be able to, if there is some issue with, the employee, partner, associate, whatever, is not part of the lawsuit for whatever reason, then where do we extend this, write it so that it could be applied to other professional organizations? I'm thinking maybe, civil engineering firms, etc.
Yeah, I don't believe so, Your Honor. I think, as pointed out, only malpractice claims are limited to those who practice medicine or practice the law. So I think, as pointed out in Worth, I think that was a big factor, that only those individuals can commit malpractice. And so I don't think there's any reason to expand it any farther than what it is. The law has always treated physicians and lawyers to a higher degree, I believe, and that's the whole reason why malpractice claims are in existence, because there's a standard of care that the law charges them to perform.
Well, Mr. Bischoff, let's say we have some kind of a civil engineer who designs a bridge, and the bridge collapses at some point, and it's discovered that the civil engineer made a huge mistake in the design of the bridge. Many people were injured, many people died. Civil engineers died by that time, so there's no liability for the civil engineering firm then?
Well, I wouldn't necessarily think so. I think there's claims for direct liability on behalf of the firm, and I don't.
The civil engineer had to be separately licensed.
Well, he wouldn't be charged with malpractice, and I think under the law of Ohio, that malpractice can only be committed by lawyers and physicians. So I don't think Worth would apply in that situation.
And Counselor, I assume that your position is it would only apply under those occupations listed in 2305.11, medical claims, dental claims, optometric, chiropractic claims, and legal malpractice claims. That's who you can sue for malpractice in Ohio. Is that correct?
That's correct, and I believe several district courts have extended it to the medical field, and I believe there's also been one or two that's extended to the dental field as well.
But Mr. Bischoff, what if a licensing board has the ability to pull that person's license? Why is it just malpractice? I mean, if it's a licensed individual and they could lose their license because they made huge mistakes or they didn't honor the terms of what it takes to keep the license, why are we making this distinguishing thing for malpractice? I mean, when the chief asked, how far can this go out? We may be opening Pandora's box by doing this today, because this was a situation where she didn't have any choice of who she saw. She showed up and she was given someone who was the technician to work on her. Whereas you go to a doctor or a lawyer, you may be choosing who you're going to be seeing.
ultimately, I don't think this would be opening Pandora's box. I think the wording of worth is pretty. The reasoning for it establishes the boundaries, I believe. Ultimately, these are individuals, lawyers, physicians, chiropractors, dentists, that are charged under the law with the standard of care, and only they have the directive to control how they perform that standard of care. And I think that is different than other licensed individuals, other licensed occupations. And I don't think that extending worth to reach chiropractics or medicine would lead to too far, would be too broad.
Thank you. Thank you,
Thank
counsel.
you.
All right, thank you, counsel. We'll take the matter under advisement, notified of our decision.
Thank you, Your Honor.
Thank you.
Our second case this morning is 2021-26, State of Ohio versus Shannon Kidd. For Mr. Kidd, we have Mr.
Thank you, Your Honor. May it please the court, I'd like to reserve 3 minutes for rebuttal. Appellate Rule 5 has no fixed deadline in it, and there are good reasons for that. One of those reasons is that sometimes a person can sit in prison for years until they understand that they actually have a reason to appeal, that their sentence is illegal, and that they should appeal. And that's why that's one of the reasons why we have Appellate Rule 5, is so that why it is open-ended, so that a person can bring a claim and show that their sentence is illegal. And that's what this court, Chief Justice O'Connor's concurring opinion in Henderson explained. Serious mistakes can happen. And it's not just this case. There are other cases where where courts have interpreted sentences to be life without parole, where someone should be parole eligible. And people should not have to die in prison because of mistakes like this. Shannon Kidd filed his appeal, first learned that he had an illegal sentence in the summer of 2020. When
Counsel,
yeah.
Your client, I guess, was sentenced at 40 to life. Was that the amount of time we're talking about?
Yes.
Okay. He is now eligible to be released after 25 years. Is that correct?
Well, you understand. I believe it's yes. Under Senate Bill 256, he did have a parole hearing. However, those rules for parole can change over time, and the one thing that remains constant is the the sentence in the judgment entry. And that if somehow if the rules end up changing, he'd be stuck back with his sentence of 40 years to life.
Well, not if he's released at 25.
Not if he's released, but there also he would still go out on parole, and if there are violations, he would come back, and it would determine, and there would be the rules, and that would yes, if he actually is released after 25, but he still could be, there could be violations. He could come back, and what's the minimum sentence after that? It could change over time. And that's why the sentence of the piece of paper signed by the judge matters.
Counsel, it's not in dispute that your client was sentenced under the incorrect law. Is that correct?
I don't think it's reasonably under dispute. I think my friend on the other side has said that because of incorrect rulings by the 8th District that it was somehow a legal sentence. I'll let my friend on the other side explain that position better than I can.
Well, what rule would you have as fashioned towards a discretionary rule for the district courts that would direct them to grant in certain situations, like your clients, the ability to proceed with their claim?
I have a broader rule and then a narrower rule. The narrower rule with the proposition of law says when two things come together, learning that you have an illegal sentence and that the procedural rules change and how you do that. However, I suggest that just the simple illegal sentence is what should matter.
So is that anytime anyone claims they have an illegal sentence, or would it be that they have to prove they have an illegal sentence to have the right to appeal? How do you square that?
But then when they show on the record, when they show in their delayed appeal motion that their sentence is illegal, the court should grant it.
So it's not just a claim that they have an illegal sentence. It would be actually making some kind of showing that they do, in fact. This is almost like you have to show the merits of the appeal before you are allowed to appeal, kind of thing.
Or I would at least say if there's something that they can at least, if they make a fanciful claim, if my client has filed something, said my sentence is illegal, I should have been given, the only sentence was probation, because I can see that, but as long as there's something plausible.
Counsel, let me ask a different question. As Justice Donnelly mentioned, this is an abuse of discretion standard, correct?
I would say when it's legal, I'm arguing a legal standard, so I would argue that it should be de novo. If the standard is if there is an illegal sentence, you should grant it. But
Appellate Rule 5, though, is an abuse of discretion standard in this court, correct?
I don't know if there is there is one case where the person gave absolutely no reason why they do it, but I would say you can have, and even within abuse of discretion, if you can show a legal error, you should be able to, that is decided de novo. I'll also point out this is the same standard that you'd apply for a 5C appeal from the prosecutor's office by leave of court. So whatever standard is set here for the broadness of breadth of discretion would apply to the state if they wanted to use their leave of court appeal.
Counselor, do we
And
know
exactly what happened, what evidence is in the record that Mr. Kitt did between finding out that he was serving a sentence of 40 years to life in 2011 through when he filed in 2020?
Well, what he learned, what the record shows is we have an affidavit from both him and from Deputy Director Beeler that says that he didn't know that that sentence was actually illegal until our office pulled the criminal file in 2020 and found a letter from 2005 from the Department of Rehabilitation and Correction that they sent to the office of my friend on the other side, the prosecutor's office, and they sent to the trial court, but they never sent to Shannon Kidd. That letter was addressed to the trial court and CC'd to the prosecutor, but not to my client. And that's when we discovered that his sentence was illegal. And that's important because just knowing that your sentence is not what you expected, disappointment isn't an appealable issue. Illegality is an appealable issue. And that's in 2020 is when he actually learned my sentence is illegal. I was sentenced under the wrong law. You can't give me Senate Bill 2 time for a pre-Senate Bill 2 offenses.
But he knew in 2011, 2012 that his sentence wasn't what he had thought it was, right? So didn't he have some duty to investigate at that point?
I think that it's not fair to put the duty of legal inquiry on understanding the Ohio sentencing laws and how they change over time over someone sitting in a penitentiary. That's why we have lawyers. That's why we have lawyers, is to tell people things like that. And when our office finally was able to pull the file from the court and look at it, and the lawyer who was looking at the file on his behalf looked at it, they said, "Oh, wait a minute, this is illegal. You can't do a sentence like this."
Counselor, we don't know why the Court of Appeals denied the leave to file, right?
Correct. It was, within days of filing. Yes, they just summarily denied it. They gave no reason. It was a one-line denial.
So is your argument here that the Court of Appeals abused its discretion because they denied leave to file a motion for delayed appeal on an issue where there was clearly a sentence imposed unlawfully?
Yes, that's one of the arguments. If we're under the abuse of discretion standard, we still win because a clear legal error would be an abuse of discretion. And there's no.
And is the illegality was manifest to the Court of Appeals at the time the motion for delayed appeal was filed?
Yes, it was in the we attached documents to the motion for leave for delayed appeal. We included the affidavit, the letter from the Department of Rehabilitation and Correction, the plea agreement, and so yes, it should have been obvious to the court at that time. I mean, the state never contested the fact that this crime occurred in January of 1996, and Senate Bill 2 became effective in July of 1996. There's never been any question about that in this case.
Thank you.
So, Mr. Harvey, the rule you want us to write, I guess, is that if there's a clear legal error that affects the length of a sentence, then it's an abuse of discretion for Court of Appeals not to grant leave to appeal. Does that sum it up, or would you?
Yeah.
What about a diligence requirement? I understand in this case you think that whatever requirement he had was satisfied, but I would presume you would. Well, I won't presume anything, but shouldn't a court be able to look at, in the exercise of its discretion, whether someone sat on their rights or whether they timely filed an appeal or timely asked for? Again, outside the case, I know you don't. I know your position in this case is that he was diligent, but in another case where someone knew something was wrong, say.
I still don't. If the sentence is illegal and they could spend years in addition in prison as a result of that, then I would still say that enough should be enough to grant leave. In there are times, one where someone was given a life sentence where the maximum sentence was 10 years and we had to correct it. These mistakes happen. Someone shouldn't have to die in prison because they waited a year too long to file their motion for leave to file a delayed appeal. There's a reason why there's no deadline in Appellate Rule 5. If we want to give, it is a safety valve rule. In another example, this court granted about 10 years after the fact in the Moore case, granted a delayed reconsideration motion where there was a U.S. Supreme Court decision that made the sentence unconstitutional.
Counsel,
Yeah.
Should this rule only apply to cases that result in a conviction through a negotiated plea agreement where neither side really tends to have any inclination to appeal such a result, as opposed to a sentence that was rendered after a trial with counsel there and the ability to correct on direct appeal any error?
I think that's a factor in his favor in this case. I wouldn't limit it to those factors because in the end, when the General Assembly says this person should have at least a chance to seek relief after a certain period of time, and the trial court doesn't do that, that's why we have appeals courts. That's why we have safety valves in the system. That's why we have rules like Appellate Rule 5 that don't put deadlines, that don't include fixed deadlines. That give people the chance to make this. And I don't think the state...
We've also instructed counsel in our recent jurisprudence that whoever has the onus to appeal, the burden's on them to correct sentencing errors on direct appeal. That you also have the post-conviction process if you have ineffective assistance of counsel to address errors in sentencing.
Well, yes, and two things on that. First of all, that Henderson decision was written about 5 weeks before we filed the appeal in this case. So that he was not on notice from Henderson. So if this court wants to limit to that, it still should grant Shannon relief. But also, as I pointed out in my brief, I cited cases from Alabama, Georgia, Illinois, Kansas, Kentucky, Texas, Louisiana, other courts that have said that you can come back, that other states allow people to come back in this extreme situation where the sentence is something that just wasn't authorized by law, where they're sentenced under the wrong statute.
Mr. Hardwick, so pre-Harper and Henderson, this would have been a void sentence, which they could have come back at any time because it would have been a void sentence. So once Henderson was decided, what was it, 37 days, and this motion was filed? So
around that time, yeah.
Should we work from the date of the decision where the law changed? Because other than that, they could have come back at any time. There was no time deadline on a void judgment.
Correct. That's what, and that's what. Yes, because that's when this court changed the rules. And I can say why he learned about this in the summer of 2020, and at that point, it would have been a waste of judicial resources to litigate a void sentence motion, given that the issue was before this court and uncertain. And either this court would rule and keep the voidness rule, and then he could file in November, or this court would have gone the other way, and we would have been arguing in the lower courts over something that this court was going to resolve one way or the other anyway. It would have been, I just don't think it would have been a productive use of anyone's time to file a motion in June or July of 2020. It just couldn't have been resolved in any way in time. And again, come back to the brief where we showed a case out of Summit County where where the 9th District has interpreted a sentence that was just for life to mean life without parole when that sentence was illegal, when life without parole wasn't an option. Another case out of the 6th District where the court didn't fix another illegal sentence involving a life sentence. These cases happen, and usually in the most serious cases, they often don't learn about this until they start to become parole eligible. That's normal. You don't until you start getting close to when you think you're going to be paroled. That's when people actually start looking at the case again and notice these things. I also want to come back to the fact that the Department of Rehabilitation Corrections in 2005 did notified the trial court, notified the prosecutor, and neither the trial court nor the prosecuting attorney took any action based on that letter to fix the sentence in this case.
Thank you, Mr. Hardwick. Ms. Miranda?
Thank you, Chief Justice O'Connor. May it please the court, Anthony Miranda on behalf of the state of Ohio. I'd like to start first with parole eligibility. Chief Justice O'Connor, you noted that Mr. Kidd is eligible for parole. When Mr. Kidd filed his memorandum in support, he was arguing that his illegal sentence unjustifiably delayed his parole consideration. But because he's eligible for parole this month, in fact, he has already seen the parole board, we respectfully submit that this is not the same appeal that the court thought it was accepting. He's already received the ultimate relief that this court can grant him. And so I would just renew.
Counsel, what's the ultimate relief that this court can grant him?
Well, so if the court were to order resentencing, he could get a sentence which would only matter to the extent he would be eligible for parole. That's really the only tangible.
And he would have been eligible for parole sooner than the 25 years that the new statute provides, correct?
Well, we don't concede that. I guess my point is, even if this court orders resentencing tomorrow, say down the line here, he's going to get the same relief he already has. He's already seen the parole board. The court can't obviously give him relief for prior eligibility.
Counsel, do you understand that this sentence is illegal?
We don't agree with that, Your Honor. At the time the sentence was imposed, the 8th District Court of Appeals issued an en banc opinion saying that Senate Bill 2 was applicable to pre-Senate Bill 2 crimes. This court obviously overruled that decision a few months after Mr. Kidd was sentenced. But from the perspective of the sentencing court, it's not clear that an error occurred when sentence was imposed. Moreover, at resentencing, at any future resentencing, State versus Thomas would control any sentencing imposed in the future. State versus Thomas, the court looked at very similar circumstances. It looked at a rape and a kidnapping charge that arose from offenses occurring prior to Senate Bill 2, and it involved a sentencing that occurred after House Bill 86, so after an amendment to Senate Bill 2. And this court said that the definite range of 3 to 11 is less than or more beneficial to the defendant than the indefinite pre-Senate Bill 2 range of 5 to 25. So even if the court were to reverse the decision to grant delayed appeal and a resentencing were ultimately ordered, State versus Thomas controls, and at resentencing, Mr. Kidd would be subject to that definite range of 3 to 11 years. The only distinguishing argument.
Counsel, what would his sentence be if we order a resentencing?
So, so opposing counsel's only challenging the non-life count, so rape and kidnapping specifically. Under Thomas, the court could impose a definite sentence anywhere within the range of 3 to 11 if there were resentencing. And the only way that Kidd distinguishes this case from Thomas is by saying he's serving an unrelated life sentence for murder. And he argues that for some reason means that Thomas doesn't control. But under State versus Saxon, we know that we don't look at sentences in totality as a sentencing package. We look at individual counts and decide what sentence is applicable to each count. And Thomas involved the exact same types of offenses, rape and kidnapping. So even if this court were to order resentencing, I think he would be subject to the same prison sentences he's serving today. But my overarching point here in asking the court to affirm is the issue of discretion. And there are two primary factors that the lower court could properly have considered in denying leave. The first is the amount of delay. There's well-established case law from lower courts that ignorance.
But Mr. Miranda, should delay really matter if it's truly an unlawful sentence?
I think it does matter, Your Honor, because it's not a cost-free decision to allow a direct appeal years later. For example, there's no transcript of this sentencing.
But I mean, therein lies a problem. I mean, if it's an illegal sentence, the burden is still upon the defendant or the appellant to show that it's an illegal sentence. So if that can't be shown, then he loses the appeal.
That's true, Your Honor. There are some arguments that are going to be that the absence of a transcript isn't going to be that dispositive. Right. Issues you can presume regularity. There are going to be other arguments, though. For example, what was Mr. Kidd's position at sentencing regarding the application of Senate Bill 2? We know, for instance, that in Delgado, in Rush, in Thomas, all three of those cases, the defendants did not want pre-Senate Bill 2 to apply. But I can't really raise a waiver argument or an invited error argument without a transcript of the proceedings. So that's an example of why the lower courts have built into the discretionary review the standard of reasonable diligence.
You have the pre-sentence investigation, though. Wouldn't that be helpful?
The pre-sentence investigation, Your Honor, is helpful to, I think, some of the facts. It's not helpful in terms of the legal positions of the parties at the time of sentencing. It doesn't indicate, for example, whether Mr. Kidd asked that Senate Bill 2 be applied.
Is there a sentencing entry, counsel? Is there a sentencing entry?
Yes. Yes, and it obviously imposed Senate Bill 2 sentences. My point is we don't know whether or not Mr. Kidd asked that Senate Bill 2 be applied, or did he object and say, no, we want a prior Senate Bill 2 to be applied. We don't have the transcript because the delay in this case is over 2 decades. And on the spectrum of motions for delayed appeals, that's an extraordinary amount of delay. We're not talking about delay of months or years. And then in addition to delay, the second,
Who's responsible for the fact that the a transcript is not available? It's the state, right?
no, with respect, it's Mr. Kidd. It's not enough in these matters. This is established not only in motions for delayed appeals, but delayed applications for reopenings. It's not enough for defendants to claim ignorance of the law.
Well, whose policy is it to destroy the transcripts after 12 years? It's not Mr. Kidd's, is it?
No, I believe it's the court reporter's policy, and that could be a local, I don't have any idea what other jurisdictions do, but there's certainly no requirement in the law that the court reporters keep that material indefinitely. And
the prosecutor's office doesn't have a copy of it either?
Correct. To my knowledge, we do not. And in fact, if it were ever prepared, if the raw material ever was made to make a transcript, then it would be made. But the court reporter doesn't.
There's no appeal.
Correct. And so then the second factor that the Court of Appeals, I think, was fair to look at is the evidentiary support presented in the motion. And Mr. Kidd claims that he didn't take a timely appeal because he was never given an appellate advisement. And the only evidence in the record in support of that claim is his self-serving affidavit. So again, there's no transcript, there's no affidavit from his trial counsel saying that no advisement was given. So on the spectrum of motions that the courts of appeals get, this is on the lower end of the spectrum. Based on those two factors.
But this was a plea, so it's kind of believable that he might not have been advised, isn't it?
It's possible, Your Honor, but again, it's the defendant's obligation to establish the basis for his delayed motion. And it's not an unqualified right to a delayed appeal whenever he wants. And the Court of Appeals, this court has recognized the lower court's discretion for 70 years now in the area of delayed appeals. And if the Court of Appeals can't deny a motion filed 22 years later, it's not clear to me what remains of the lower court's discretion. I'm not sure what circumstance still exists where it can reasonably be denied.
Counsel, what weight do you give the letters that were received by the prosecuting attorney's office and the court in, I believe, 2005?
Yes.
Identifying the illegal sentence. What weight do you give that?
So the letter sent from the ODRC to the court raised an issue about whether the sentence was consistent with Senate Bill 2. Obviously, the letter was sent after the court's decision in Rush. It doesn't speak, however, to the issue of delay. It doesn't say anything about whether Mr. Kidd was advised of his right to appeal. So it's not it.
That's not what their intent of the letter was. The intent of the letter was say, here's a red flag. There's a problem here. It should have gone to Mr. Kidd, or at the very least his last counsel. Instead, it went to the court and to the prosecuting attorney, both of whom did nothing.
Your Honor, we received a copy of it, but it was directed to the court. It raised an issue. It didn't, it obviously didn't command the court to do anything.
Well,
but certainly
the letter, the ODRC can't command the court to do anything.
Right, correct. So it raised an issue. Certainly Mr. Kidd could have, under the prior voidable sentencing jurisprudence, could have raised the issue at any time, and he never raised that issue, despite knowing in 2011 or 2012 that his assumption that he'd be eligible for parole after 14 years was untrue. He knew that in 2011, 2012, and he didn't file his motion for delayed appeal until 2020, more than 8 years later. And that's That's just simply not, there's no justification for that amount of delay.
So he went into the prison system as a juvenile, right?
He committed the crimes as a juvenile. At the time of the plea and sentencing, he was 18, or 18 or 19, but he committed the crimes as a juvenile, yes.
Well, I'm going to assume for the severity of the crimes, he was locked up from the time he was under 18, correct?
He was locked up for an unrelated offense, and so there was a delayed prosecution of a few years. So the crime occurred in 1996. He was sentenced in 1998. So he committed the crimes as a juvenile. That's why he gets the benefit of Senate Bill 256. However, at the time of the plea and sentencing, he was an adult.
Thank you.
And so I would just, again, I would emphasize the policy concerns we have with granting delayed appeals after so much delay. I've already referenced the fact that there's no transcript and why I think that raises issues for litigation. We cited to an 8th District case where they had granted a delayed appeal after a long period of time and really, I think, regretted it, openly expressed a question about whether or not it was improvidently allowed. That's State versus Hunt. And then lastly, there is a real harm to the finality of judgments and the victims' families who are notified after 2 decades that issues they thought were settled are now subject to fresh litigation. That's not in the state's judgment.
Counsel, let me ask you, what kind of an illegal sentence do you think should be the subject of a delayed appeal?
Your Honor, I don't dispute that Mr. Kidd could raise this issue in a delayed appeal. I'm just submitting that it's not an unlimited right to a delayed appeal. He has some obligations of diligence. And, if he had filed his delayed appeal days after this court's decision in Rush.
But Ms. Miranda, doesn't that assume, as was mentioned earlier by one of the justices, by counsel, Mr. Hardwick, that non-lawyer defendants are to know all the rules?
Yes, and defendants are held to some expectation that they exercise their rights, not only in the delayed appeal context, but in other contexts like untimely applications for reopening.
They are, but isn't there also a recognition of the inability to facilitate representation when you're incarcerated?
Certainly, Mr. Kidd could have sought representation. There's no right to representation post-conviction.
Right. So if he's indigent, if he can't afford his own lawyer, and he's contacting the public defender's office and their backlog, or he can only wait until someone responds. I mean, but you're right. It's not an unfettered right to have a delayed appeal granted, but it has to be tempered with what the appeal would show. And if we're talking about an unlawful sentence, it seems like time restraints should be a little more loose than maybe some other instances of delayed appeals.
I understand that, and I would just again emphasize 2011, 2012, there's a highlighted problem for him, and his motion's not filed until 2020. So
counsel, would you say that given the lack of resources, legal resources, in other words, access to an attorney, that there should have been a pro se filing by the defendant who presumably has an abbreviated education level and to make this argument for a delayed appeal, again, pro se?
Yes, Your Honor. He had that.
That's what you're saying that should happen to in situations such as this, a pro se appeal.
Yes, I respond to pro se motions like that. There are other remedies such as post-conviction petitions that we see that are pro se. So we think the remedies that exist are adequate. And for that reason, we would ask the court to affirm.
Thank you. All
Thank you.
right, Mr. Hardwick, I think you used all of your time, if I'm not mistaken. So I'll give you a minute.
Thank you, Your Honor. There is no reasonable way why counsel in this case would have requested to be sentenced under Senate Bill 2. You have the same maximum sentence under both laws, life, but under Senate Bill 2, the trial court can make parole eligibility as late as 53 and a half years, and under pre-Senate Bill 2, the limit is 32.2 years. There is no trial counsel would have had to be insane to have made a request like that. I'd also like to, when it comes to which law would apply, I don't think there are also ex post facto issues involving increasing the range of a person's prison term after the fact. And again, the statute, I think, does apply differently in these cases. Finality is an important virtue, as my friend on the other side says, but it is not the only virtue. Sentencing someone within the lawful limits is an important part of our justice system. Imposing a sentence, courts should only impose sentences that are within the range provided by the General Assembly, and when they fail to do so, courts allow remedies that delayed appeals to be granted.
Counsel, one question. Is there anything in the record about Mr. Kidd trying to get counsel from 2011 or 2012 through 2020 or to file something?
No, it says our office just gave him general information about Graham, but nothing else. What it does show is there's a plausible explanation. The fact that once we have an affidavit from a lawyer, an officer of the court who said, we pulled the file, we discovered the error, we told him about the error, and that's when I believe he learned of the error. That's when I talked to him, that's when he learned of the error. So there is an affidavit from an officer.
What was the date of that?
That was 2020. That was in 2020, just before we filed the motion for.
I got you. Thank you.
Thank you. Thank you, Your Honor.
All right, thank you, gentlemen. We'll take the matter under advisement and be notified of our decision. Marshall, we call a 10-minute recess.
The court will now adjourn for 20-minute recess.
10 minutes.
10-minute recess.
clerk? Our next case is 21-151, Doreen Barrow et al. Versus the Village of New Miami. For the appellant, Mr. Engel.
Thank you, Your Honor. I'd like to reserve 3 minutes for rebuttal. Chief Justice O'Connor, and may it please the court. The Village of New Miami and its commercial partner reaped huge profits by establishing a bare bones administrative process designed not to maximize public safety, but to maximize revenue. The procedural due process guarantees of the Ohio Constitution prohibit government entities from levying fines on individuals without providing a meaningful opportunity to challenge the basis of that decision. The system before the court today was consciously designed from the beginning to cut off any ability of a motorist to contest that they were not speeding. A motorist has no ability to independently verify that the equipment operated remotely by a Maryland corporation was working correctly. The record here shows that there was little to no real interest in public safety. Instead, the math was simple. The more people who pay fines, the more money flows into the bank accounts of the village and its business partner. The overwhelming majority of people who received citations saw this for what it was, a system where the cost of challenging a ticket combined with the small likelihood of success meant motorists were coerced into paying fines. The Ohio Constitution guarantees some ability to test the evidence used by the government. These tests are not hurdles designed to make government inefficient. They're designed to assure citizens that the decisions made by the government are accurate and reliable.
Counsel, assuming we agree with you completely, if we issue an opinion, how many jurisdictions will that affect? How many jurisdictions are following this current procedure?
At the moment, Your Honor, we believe that no one is following the current procedure because the legislature has taken a number of actions that prohibit this type of operation.
So we're trying to amend it 1901?
I'm sorry, Your Honor?
Revised Code 1901, the amended statute, 1901.20?
Yes, the current statute, the current law provides a number of restrictions on the ability of speed camera operators to do what they did here, which is set up these separate civil administrative procedures.
So what would a decision by us do?
I'm sorry, Your Honor?
So what would a decision by this court, what effect would it have?
A decision by this court would have two main effects. The first effect is for the motorist who paid fines under an unconstitutional scheme by the village, they would get their money back. And that's only right and only fair, that people who were subjected to unconstitutional actions of the government should receive refunds for that. Second, Your Honor, and perhaps more importantly, is a decision by this court would have a reach far beyond just speed cameras. Because if the court were to say that if a municipality imposes fines low enough, they can create civil administrative procedures that swallow up all the criminal law and can be used to raise revenue and not have to provide any due process. So what the decision of the court here today will do will be to set standards not only for speed camera cases, but for all the future actions that municipalities might take in order to raise revenue on what used to be criminal violations and would now be called civil administrative actions, whether that's the use of facial recognition software or drones or the like in the future. This court has the ability to set rules and say to municipalities that regardless of your justification, you still have to follow and provide due process under the Constitution.
Thank you.
Now, nobody is suggesting, and I'm not suggesting, that the village was required to hold a full criminal trial or that the village was required to strictly apply the rules of evidence. And nobody is suggesting that the village was prohibited from using photographs and speed data obtained from a private company as evidence to establish liability. But we are suggesting that the constitutional guarantee of a meaningful hearing prevented the village of New Miami and its private business partner from doing what they did here, using a veneer of public safety to privilege expediency and profits over reliability and accuracy. The program here was unconstitutional because it deprived motorists of the most fundamental requirements of due process, a meaningful hearing. The Second Circuit in the Tony decision and the 12th District in this case recognized that a motorist wishing to say, I wasn't speeding, the radar is wrong, faced a nearly insurmountable burden. So here's the basic idea, Your Honors. Trust but verify. This court has never approved the use of an administrative scheme with the two primary features of the ordinance in this case. First, that the evidence used to fine an Ohio citizen is obtained from a private company with an interest in the outcome. And second, that the person who is subject to a fine or an adverse administrative action has no ability to review the relevant records or the persons responsible for creating the evidence. This would be like if you received a property tax bill and the property tax bill contains an appraisal of your property, but the government simply says, we know we have this appraisal of the property that we received from a company out of state, but you're not able to see how we calculated the figures, and you're not able to challenge those figures in any meaningful way, except if you file an action in common pleas court later, paying 3 times the amount of tax due as a filing fee, and then maybe we'll consider giving you some discovery.
So, Mr. Engel, if we agree with you, this then is remanded back to the trial court to configure, to deal with execution under the class action.
Yes, Your Honor, there's a judgment that's already been entered in this case requiring the village to pay restitution in the full amount of the money it received. Judge Oster in the common pleas court made 2 decisions that would be challenged if the court agrees with us. And so what would happen is that this court would remand it to the 12th District to consider the amount of interest to be provided under that restitution payment and whether that restitution has to be paid right away or could be paid over a 10-year period of time, as Judge Oster had suggested. But there is a final judgment, to answer Your Honor's question directly. There is a final judgment in this case that the motorists are entitled to receive back all the money that they paid under this program.
But the class action, whatever the award is, would have to be administered, and that would be administered by the trial court, correct?
That is correct, Your Honor. It would be a common fund was created by the judgment of the common pleas court. So all that money, that money, the total amount due to the motorists would go into a common fund, and then there would be an administrator who would be in charge of paying the money back to all the motorists. That would be also under the responsibility of counsel to make sure that all the motorists got what was due to them to be refunded.
Thank you.
So I think it's important, Your Honors, for the court to recognize that what's at stake here is not merely $95, but what is at stake here is what's a significant amount of money to a number of working people. You can consider, for example, that the $95 fine in this case is almost a day's pay for someone who's working minimum wage. But I think it's more important to consider that a number of motorists received multiple citations. And looking at the record, there's a motorist named Vicky M. who received 8 citations over a 13-day period in 2013. Another woman by the name of Brittany G. received 10 citations over a 10-day period in May of 2013.
Also, Counsel, I'm presuming there was no signage to let the motorists know that there was a camera?
My understanding, Your Honor, was that there was a small sign that said that speeds are enforced by video or by cameras. But I think what's really important to consider is that unless that sign slowed people down, the woman who received 10 citations over a 10-day period in May would not have even known that she was speeding at the time. And so if the purpose was to slow her down, that wouldn't have happened.
Counsel, you're saying the woman didn't know she was speeding. She was driving her car, was she not?
She was, Your Honor, yes.
Okay, and isn't it the duty of a driver, one of the primary duties of a driver, is to know how fast they are operating their vehicle within the confines of the speed limit?
Of course it is, Your Honor. But what's important is that when a motorist receives a ticket, it is not unheard of in the courts of Ohio or administrative procedures for a motorist to say, I wasn't really speeding. I know, state trooper, if you're on the interstate, for example, I know, state trooper, that you have a radar device saying I was going 78 miles an hour, but I was looking at my speedometer and it said I was only going 68 miles an hour. And what's really important in this case is that if that motorist, Brittany, wanted to come into the hearing and say, I don't think that the cameras were operating correctly, show me the calibration records, find me the person who did the maintenance on that. And you compare that to how it would work in a municipal court. In a municipal court, a state trooper, before every time they go out and speed, would have to testify, or catch someone speeding, has to testify that I checked the calibration. They'd hold up the little tuning forks in front of the radar device or do whatever is necessary to make sure that the device was operating correctly. And the person would have the ability to ask them and show that the device was operating correctly. That doesn't happen in this case, Your Honor. So to directly answer your question, if Brittany thought that she wasn't speeding and she believed that she was operating that, she would have no real ability to challenge that. And that's not just my opinion. That was what the 12th district said in this case, and it's what the 2nd district in Tony said. They said that a motorist who wished to challenge that conclusion would face significant obstacles. And respectfully, that should have been the end of the Matthews analysis, because you don't have a situation that gives you a meaningful hearing if you can't assure that you're receiving accurate and reliable results. And more to the point, a motorist is not required to take the word of the government and its business partner that they were speeding, but they would be entitled to at least look at the records that would show that the machines were operating correctly, which doesn't happen in this case. That's why this program was unconstitutional, and that's why we'd urge you to affirm the decision of the Common Pleas Court finding it unconstitutional, and then remand it to the Court of Appeals to consider some of the issues remaining on restitution.
Thank you.
With that, I'll reserve the rest of my time for rebuttal. Thank you, Your Honors.
Okay, thank you. Mr. Engler.
Good morning, Chief Justice O'Connor, and may it please the court. James Englert for the Village of New Miami, and I'm accompanied by my co-counsel, Anthony Raleigh, who's in the room but not on the screen. Your Honors, thank you for hearing this case. The first issue that I want to go with is I think the first thing that Mr. Engel raised, that is the matter of revenue that is raised. And he seems to substitute the concern for speeding that this village had and substitute in raising revenue as the object of this ordinance. And that is pure speculation. And also it's forbidden. There's nothing in the record that establishes that. The record with regard to why this ordinance was started was that the police chief was approached by villagers who, as they were coming out of a playground onto Route 127, four-lane highway, major thoroughfare north and south in that part of Ohio, that there was speeding. There had been a serious accident before. The police chief went in his car for a month and a half with radar, measured the speeds in an unmarked car of cars going by, found that there was an issue. Council was also concerned about this, and in the record, the council says that for the ordinance, they cited as the reason the ongoing problem of motorists disobeying speed limit control devices contributing to a significant number of motor vehicle accidents.
Counselor, excuse me.
Yes,
Maybe
Your Honor.
if you have 15 minutes, we could talk about your legal arguments a little bit. What about, as I understand it, part of your argument is that because there's an appeal to the common pleas court, the procedures don't matter that happen in the administrative proceeding. Is that right?
That's not how I would characterize it, Your Honor. I would characterize the 250603 appeal to the common pleas court as a safety valve for the, frankly, fairly rare instance when motorists would want to challenge and go sort of like deep into the weeds and obtain the testimony of somebody from Optotraffic, subpoena him to come in.
So just help me understand how we're supposed to evaluate that. Are we supposed to say that because there's an appeal, any problem with due process in the first level is fixed because you have those rights in the common pleas court?
Well, we're saying our position is that the process that is given below is indeed meaningful due process. And I need to take issue with any number of things that Mr. Engel said about the inability of the motorists to defend themselves. They are allowed to do that in the hearing. They can make their own case. They can bring witnesses. They can bring in an expert witness. It could be their brother-in-law who's an electrician and knows something about radar.
Well, okay. Excuse me, but
yes,
they could bring in an expert witness. Would that expert witness have the ability to look at the calibration records?
There is a means to do it, and it did happen in this case. The hearing officer, Mr. Iona, testified in his deposition that there had been individuals who used a FOIA request, a public records request, to obtain records and to bring them to the hearing. So that would be possible. And FOIA is not a difficult thing to do. The village turns over its records, which would include calibration, and then the expert can look at those.
But
So
Mr.
that
Englert,
is
Mr. Englert, is that really the right to confront your adverse witnesses? If you can't, I mean, if those hearings, you can't bring in the person from the company and interview them as on cross.
That's correct, Your Honor. You're not able to do that at that stage. And it is an administrative hearing. And the case law in Ohio, the case law that we've cited, and it's law in Ohio and pretty much throughout the country, says that there is not a right to confront witnesses in administrative hearings. Now, certainly there are going to be situations where courts have ruled that needs to happen. And that's where you have a significant deprivation, some ongoing stream of income, or in the Doe versus University of Cincinnati case, the Sixth Circuit held that there would be a right of confrontation of the accusing witness. But the factual situation there was an accusation of sexual assault. And so there are many big interests that are involved in that. The student was going to be expelled from school, and in that case it held. But under Matthews v. Eldridge, it's a sliding scale. You have to look at the private interest at stake, and then the lesser the private interest, the lesser the amount of process that is due. $95, and let me speak to $95. I agree, it's not an insignificant sum, but it's a fairly modest sum. When you look at the scale of all of these cases, it's at the lower range of them. It's also at the lower range of civil offenses that most municipalities have in their codes. It is, as the court in Phillips v. New Richmond said, this is an amount that is proportional to the dangerous offense of speeding.
So how much does it cost to file a 2506 appeal? What's the filing fee?
The filing fee for an administrative appeal is $285 in Butler County, Your Honor.
Counsel, let me change subjects a little bit. In light of the recent amendments to Section 1901.2 of the revised code, Village of New Miami, does it follow those requirements?
It does, Your Honor.
Okay, and there is a settlement with the plaintiffs. There's a common fund that's been created.
Not a settlement in this case. There's a judgment against the
A judgment. I'm sorry, a judgment. Yeah, okay.
Yes,
But there's
sir.
a judgment, right?
Yes, Your Honor.
So
For $3.2 million, Your Honor.
how much?
$3.2 million.
3.2. So why should this court care about this case? Or
Well,
should we?
I think that there are two reasons. I mean, one, I think, yes, it is very limited in its direct application. To the village will lose that revenue that we believe that it obtained, under due process. The other instance, though, is I mean, if the court would rule that any violation for any civil offense that has a penalty of $95 or more is going to get a lot of due process, a lot more due process than it presently requires. And there are many civil offenses for $95 that are out there. It can be as little as not keeping your yard clean. There can also be occupational issues and licenses that are involved.
Counsel,
Yes, Your Honor.
procedurally, the Court of Appeals agreed with you, right?
That's correct.
All right. So the question is, why don't we, if this has no far-reaching ramifications, not great general public interest, 1901.2 takes care of the problem. Would this be an opportunity for us to improvidently allow this case?
Your Honor, I believe that it would, and there was an amicus brief filed to that effect. There is also the fact that the court does not need to rule on this because there is a large body of Ohio law. Ohio cases are all on the side of the village here in upholding the due process. Cases out of the Second Circuit, the 12th Circuit, and 4 or 5 federal cases as well out of Cleveland.
Are any of those cases to have as little process as this one? This one seems to be at the kind of the extreme end of all those cases.
Justice DeWine, all of those cases in Ohio and the municipalities we're talking about are Akron, Cleveland, Trotwood, West Carrollton, New Richmond, Dayton. The ordinances are extremely similar. In none of them is there the right of confrontation or the right to subpoena or to obtain discovery of records. So the law is pretty clear in Ohio. I do believe, and if you look at the greater due process analysis that's at stake here, I do believe that it's firmly within the range of affirming due process, and that this case does not present a great general interest that the court needs to weigh in on. Your Honor, if I could talk for a moment about the fact that that there is no ability, that this hearing is not meaningful. The first requirement in the second Matthews factor is the risk of erroneous deprivation. We start out actually with a small risk of that, and for one thing, the speeding doesn't start. No citations are issued until you are 11 miles or more above the speed limit. So there's already a wide margin of error there. And then the equipment that is used, it is, we believe, reliable. There is unrefuted evidence in the record from a consultant in this field who testified about the calibration, the annual calibration of the machine, the daily calibration to ensure that the timing is right. They use satellite signals to do this. Optotraffic, the company that was running this, came out 2 to 3 times a week, shut down the entire system, ran through the maintenance, made sure that all the sensors were collected. The sensors use LiDAR. It is reliable information, and so satisfies the due process element there. Mr. Engel says that it's different when there is a declarant with an interest in the outcome, and he's talking about Optotraffic, the company that the village contracted with. We do not think that is that should be a significant factor. There are numerous cases that indicate, including I think it's the 7 case, Your Honor, that says that if that company is not participating in an adjudicatory role, then you can't look at the fact that it is making some money out of this instance.
Mr. Engler, Mr. Engler, isn't this kind of akin to letting a bail bondsman be a probation officer? I mean, look, the company has an interest in making money. So if the calibration was just a little bit off, it's going to make more money, isn't it?
I suppose that it is, Your Honor, but first of all, there's nothing in the record to indicate that occurs. I mean, plaintiffs have absolutely no evidence that either, Optotraffic is incompetent or that it is self-interested to the extent that it would somehow set the machines up in some way.
I understand
that would not yield results.
But excuse me, but there's no way in this procedure to test for that kind of bias, is there? Unless you go to Butler County Common Pleas Court and pay $285.
Well, you could do the FOIA request to get the records, and those records would indicate that they met the calibration. And there's a requirement that the day before, the day of, the day after, that the records indicate that the self-testing has occurred before a notice of liability is issued. So, but if you're going to, but if you do want to actually examine, cross-examine the people at Optotraffic about how they set this up, yes, you would have to go through a 2506 appeal.
Thank you.
Thank you, Your Honor. Your Honor, I'd like to bring up the matter that this is a facial challenge here. The standard of review is extremely demanding in a facial challenge. First, there has to be no set of circumstances under which the ordinance could be applied constitutionally. And I think that knocks out immediately the second proposition of law, that is where plaintiff says that the affirmative defenses are not sufficient because it requires the owner to identify a driver who is actually driving if the owner was not at the time. That's only, that is one set of circumstances. It wouldn't include most set of circumstances that happen. In addition, the standard, the burden is that plaintiff has to prove beyond a reasonable doubt in this instance. And here the claim would be that he has to prove beyond a reasonable doubt that that a driver has no opportunity to defend themselves. We think that is not the case. There are these opportunities that we've talked about, and no opportunity to raise any kind of defenses. So the law on this is clear in Ohio. This court ruled itself in the Mendenhall v. Akron case that the Akron ordinance passed constitutional due process. It wasn't an involved analysis, but it is in the case. And at the same time, the court cited the Chavez case, the Agomo case, and a third case, all of which upheld due process. Plaintiff, Your Honor.
You used your time. Thank you.
Thank you very much, Your Honor.
Mr. Engel.
Thank you, Your Honor. May it please the court. This court should decide this case and not decide that it was improvidently granted, because this case has far-reaching implications. It has implications not just beyond the $3 million plus that motorists would be entitled to receive as refunds if this court doesn't affirm what the Common Pleas Court decided in this case. Because this is the beginning, and the court will likely see similar cases and similar claims by municipalities in the future. Dismissing this case as improvidently granted, I would suggest, Your Honors, would set a terrible precedent. You would be saying essentially that a village can collect a ton of money and then avoid any kind of judicial review by making a small change in the law later and then saying, well, things are moot. We're not doing this anymore. We're doing something different. And then they keep the money and they will repeat this process again and again. Or as technology advances, you will see similar problems come up again and again, and you will see similar efforts by villages and municipalities who are cash strapped to try to leverage a claim of public safety into an administrative hearing designed primarily to generate revenue. I think the conversation that Your Honors had about public records really illustrates the danger here.
So for a minute here, you just said something that I heard Mr. Englert refute, and that was the intent to raise money, that this was just a scheme to raise money. And he explained that that is not nowhere, except maybe in your statements, is that been found. In fact, there's legitimate evidence that the chief of police, verified the speeding as being a problem. Parents, village residents, concerned about this. So to continuously say this is just a money-making scheme without any evidence to that, any authority, I'm not sure that that's the way to present.
Well, if I may respond, Your Honor, I know I'm out of time. If I may use some time to respond. Two responses, Your Honor. First, the evidence that the village cites is really very thin. I'd refer the court to page 12 and 13 of the deposition of the chief, because he says simply, well, I received a couple of complaints, and then I sat out there and I jotted some notes on a piece of paper, and next thing you know, we're instituting this program. That is not the type of evidence that has typically been required. And the court needs to go no further than look at the record in the Tony decision before the second district, where the city of Dayton did a number of very detailed traffic studies and determined how the program would actually increase safety, and then went back and, more importantly, checked its own work. What you don't have in this record at all is any evidence that this program actually reduced speeding. But what you do have, and what leads to...
You've used your time. Thank you, gentlemen. Thank you. We will take the matter under advisement. You'll be notified of our decision.
Thank you, Your Honors.
Good morning. Our last case this morning is 2021-166, Michael P. French et al. Versus Ascent Resources Utica LLC appellee. For the appellants, Mr. O'Farrell.
Madam Chief Justice, Justices, may it please the court, my name is Josh O'Farrell. I represent a family who owns 175 acres in Jefferson County. They're the appellants in this matter. I'd like to reserve 3 minutes for rebuttal. No one will argue today that controversies involving Title II or possession of real estate are not excluded from arbitration under Ohio law. They are. Rather, the point of disagreement is whether the claim asserted by the appellants in this litigation triggers that statutory exclusion. That claim is one for declaratory judgment, in which the appellants seek a judicial declaration that Ascent Resources Utica failed to satisfy certain mandatory requirements necessary to maintain the oil and gas leases in effect beyond their primary terms, resulting in those leases terminating by their express terms and operation of law, and the fee simple determinable created by those leases reverting to and revesting in the appellants. The 7th District Court of Appeals, in reversing the trial court, concluded that appellants' claim for declaratory judgment failed to trigger that statutory exclusion. In doing so, the 7th District refused to apply this court's clear precedent as established in Chesapeake Exploration versus Buell and Brown versus Artex Oil Company. The precedent established by this court in Buell and Brown makes clear that in Ohio, oil and gas leases affect possession and custody of both the mineral and surface estates. The 7th District refused to apply this precedent when it held that oil and gas leases are not issues concerning Title II or possession of real estate. This court's precedent makes clear that oil and gas leases are grants that transfer a fee simple determinable in the oil and gas estate to the lessee during the term of that lease. Again, the 7th District rejected this precedent and mischaracterized the nature of oil and gas leases in Ohio when it held that oil and gas leases at issue in this case do not grant Ascent Title II or possession of real estate, and only permit Ascent to use the appellant's property to search for and produce oil and gas. This court in Brown held that an action to recognize the reversion of mineral interests following the alleged termination of an oil and gas lease by its express terms and operation of law is not an action upon a written contract. Rather, it is akin to that of a quiet title action. The 7th District refused to apply this precedent when it rejected this argument, failing to recognize that the claim asserted by the appellants in this matter is the substantive equivalent to that of a quiet title action. Notwithstanding the fact that the 7th District recognized in its opinion that actions to quiet title are controversies that directly involve questions of Title II or possession of real estate and are therefore not subject to arbitration under Ohio law, a point Ascent also concedes. The 7th District's conclusion, Your Honors, that appellants' claim fails to constitute a controversy involving Title II or possession of real estate and is therefore not excluded from arbitration under Ohio law is tenable only by that court's rejection and misapplication of this court's precedent. Appellants request this court reverse the 7th District Court of Appeals and reinstate the trial court's decision. Doing so will, 1, reaffirm the fundamental principle that Ohio's appellate courts and trial courts are required and bound to follow and apply this court's precedent to the legal issues before them. 2, restore clarity to Ohio's lower courts that actions in which a lessor seeks a judicial declaration that an oil and gas lease terminated by its express terms and operation of law as a result of a lessee's failure to satisfy certain mandatory requirements identified in the lease constitutes a controversy involving Title II or possession of real estate and is therefore not subject to arbitration. And 3, ensure that lessors seeking such a declaration are not forced to arbitrate such claims in clear violation of this state's long-standing public policy to the contrary. After thoroughly analyzing the competing arguments, the trial court correctly determined that this case presented a controversy of both title and possession of real property, and as a result, was excluded from arbitration under Ohio law. In elevating substance over form, the trial court emphasized that it is the potential result that triggers the statutory exclusion, not the grounds asserted for that result. The trial court recognized that if it declared that the leases were valid, then Ascent would retain all possessory rights associated with those leases, including the right to use the appellant's surface estate to build permanent facilities, such as wells, roads, pipelines, and telephone lines. However, if the court determined that the leases expired and terminated by their express terms as asserted by the appellants, then Ascent would lose all of those possessory rights as they would cease to exist the moment those leases terminated.
Mr. O'Farrell, when the lease was renegotiated or provisions were added in 2014, the provision on arbitration was any questions concerning this lease or performance thereunder. So if it's a question of performance on declaratory judgment, can that be excised from the greater issue of affecting title to determine that narrow issue of whether or not the lessee had actually performed under the lease?
Thank you, Your Honor. This is not a controversy relative to contractual performance or non-performance. As Justice DeWine aptly observed in the oral argument in Brown, just because a lease terminates or a contract expires doesn't necessarily require that a breach exists. There's no breach here. As such, there is no question whether or not performance or non-performance was due. Rather, whether Ascent commenced operations as required in order to perpetuate this lease beyond its primary term and into its secondary term was a purely discretionary act. Ascent could either commence operations by fulfilling those obligations in paragraph 33 or not. But if it chose not to, that doesn't constitute a breach of contract. It's for that reason that the appellants did not assert a claim for breach of contract, because their failure to commence operations did not result in any damages to the appellants. Rather, it simply operated to terminate that lease by operation of law. Recognizing that this case constituted a controversy involving both Title II and possession of real estate, the trial court went on to cite the 7th District case, In Re Ball. In Re Ball, the 7th District Court of Appeals recognized the following precedent as established by this court in Buell. Precedent the 7th District chose to ignore and completely contradict in this case. That precedent is: oil and gas leases are title transactions. Oil and gas leases grant a fee simple determinable in the mineral estate to the lessee with a reversionary interest retained by the lessor that can be triggered by events or conditions specified in the lease. The rights and privileges granted pursuant to an oil and gas lease are sufficiently vast to affect possession and custody of the mineral estate. Oil and gas leases affect the surface estate because the lessee enjoys reasonable use of the lessor's surface estate to accomplish the lease's purpose. And last, oil and gas leases affect possession of both the mineral and surface estates. After considering and applying this court's precedent, the trial court correctly concluded that appellant's claim for declaratory judgment constituted a controversy involving Title II and possession of real estate, and was therefore not subject to arbitration. The 7th District reversed the trial court's decision. In doing so, the 7th District rejected and or ignored this court's clear and binding precedent as established in Buell and Brown, despite its obligation to follow and apply that precedent to this case. The 7th District's decision was constructed on the faulty legal conclusions in direct contravention of this court's precedent. 1, the 7th District held that even though oil and gas leases create an interest in real estate, they are not issues concerning Title II or possession of real estate. There is no dispute that appellants hold title to the Sutherland farm and no indication that appellants' title to or possession of the Sutherland farm is at stake, regardless of how this action is resolved. 2, resolution of appellant's claim for declaratory judgment seeking a judicial declaration that Ascent failed to satisfy certain mandatory conditions required to maintain those leases in effect, resulting in the termination of the leases by operation of law and their express terms, does not involve issues of title or possession of real estate. And 3, the oil and gas leases at issue do not grant Ascent title to or possession of real property and only permit Ascent to use the property to search for oil and gas. And therefore, this controversy is not excluded from arbitration pursuant to revised code section 2711.01B1. Significantly, Your Honors, in its opinion, the 7th District recognized that a claim to quiet title constituted a controversy involving title to or possession of real property and would therefore be excluded under Ohio law. I'd like to reserve the balance of my time, Your Honors, for rebuttal.
Thank you. Thank you. Counsel, you have to unmute yourself, please, Mr. Burford.
Thank you, Chief Justice O'Connor. Chief Justice O'Connor, and may it please the court, Matt Blickensturfer on behalf of the appellee Ascent Resources Utica, LLC. Your Honors, what does it mean for a controversy to involve title to or possession of real estate? The question doesn't answer itself because many, perhaps most, real estate disputes implicate title or possession, even if only in theory or indirectly or tangentially. So there's a line that must be drawn here, Your Honors, and the question is where to draw that line. The landowners here offer and urge what is in fact a very broad interpretation of the exception to arbitration, cabined only by an artificial limitation to this specific type of case. But Ohio courts of appeals have long adopted a narrower interpretation of the exception and in general apply the exception to disputes in which the title or possession questions are directly presented, not to those disputes where an effect on title or possession might be an indirect result.
So let me ask you, here, they titled their claim an action for declaratory judgment. They could have just as easily called it a quiet title action. Why should and I think a quiet title action is pretty well assumed is exempted from the Arbitration Act. So why should it matter if they call it declaratory judgment instead of quiet title action?
Well, I think I agree with, the premise of your question, Justice DeWine, which is we need to look at the substance rather than the labels and the form of the complaint here. To look at it from the other direction, to try to get at the answer to your question, they didn't have to say anything at all in this case about title or possession. They could have presented a declaratory judgment claim that simply asked for an interpretation of paragraph 33 of the addenda to these leases and how that fit within the context of the leases as a whole. That's really what their case is about. And with that declaratory judgment armed in that hypothetical case, this case would have been over because everything else would have been decided as operation under operation of law. The issues as to the lease's continuation or its termination are questions that would happen automatically. They flow automatically from the interpretation issue of the lease. So yes, they could have styled this perhaps as a quiet title action, But again, the substance and the crux of their claim is an interpretation of certain lease provisions.
Even if they had established a quiet title action, do you think you could make the same argument you're making today?
I think I could, Your Honor, in the context of this case and perhaps in other cases, because I think our whole position here is that we need to look at the substance of the claims and not the form they're presented in, because otherwise what is sure to happen is that claims will be framed in a way that is designed to avoid arbitration clauses. They will be framed in a way to try to link in a title question, a possession issue, no matter how untenable that linkage may be. So, I would suggest, Your Honor, that the substance of the claims and the core of the case is what's important here, not the label that gets slapped on it. I believe I heard opposing counsel agree with that proposition, and I guess we just disagree in the context of this case about what looking to the substance of the claim means in this case.
But Mr. Blickensberger, if there's a dispute about whether the lease has expired, it still affects title, doesn't it?
If there's a dispute about whether the lease affects title, it will eventually I should say in the context of this case, affect whether the mineral estate is still, whether the lease is continuation or not, and whether the lease is expired or terminated by operation of law. The point that we're trying to make, Justice Brunner, is that that's several steps down the road, and it's not even clear that the plaintiff's theory will get them there. And so what we have is an argument about a particular provision of the lease, which perhaps, maybe, through some chain of events and arguments may tie into the habendum clause in this lease. But we don't know this at that stage, at this stage of the litigation. And in fact, there may be, if their theory is wrong, there's no issue whatsoever here about title or possession. And as I indicated, that title of possession issue is one that's determined by operation of law here anyway. It's not a case where we're fighting about whether the lease was validly entered. We're not fighting about the identity of parties. Those things are all not in dispute. We know who the fee owners are. We know that Ascent is the successor in interest here. We know that this lease was entered. And we know that if certain events occurred or not occurred, the lease may or may not continue by operation of law. But none of those things are central to this case, Justice Brunner. And your question to opposing counsel, I thought was, I would like to follow up on that because I think it's a great point, and it feeds into the point I made earlier. You asked, is there a performance issue here that's sort of separable from the impact on title or possession? And the answer is yes, there is. This case could have been framed, as I indicated, simply as a deck action that asked for the interpretation of paragraph 33 and how the interplay of paragraph 33 of the addenda with the rest of the lease. And that's all the court would need to decide in this case, because everything else flows automatically from that one way or another. I would suggest, Your Honors, that the narrower interpretation that has been the prevailing approach of the Ohio Courts of Appeals for decades is in fact the appropriate one here for a couple of reasons. First is the text and the structure of the statute itself. The General Assembly's chosen language is narrower than the category of all real estate disputes. And its language limits the exception to particular types of real estate disputes. In addition, this exception is in the very statutory provision that creates Ohio's strong public policy of favoring arbitration. So where we have a statute that is pro-arbitration and should be liberally construed, its exceptions should be narrowly construed. And here, the exception for a particular type of real estate dispute should not swallow the pro-arbitration rule as to other real estate disputes. Second, as I indicated earlier, the broad interpretation urged by the landowners will encourage creative pleading, and it will reward efforts to avoid arbitration agreements. It is possible in many arbitration or in many real estate disputes to come up with some theory or a remedy, such as rescission or specific performance, that seemingly turn a typical real estate dispute into some dispute about title or possession. By way of example, a dispute over whether the property falls or whether a use of property falls within or outside the scope of an easement could be turned into a dispute over possession, because the argument would go that use impacts the owner's possession. Or a commercial lease dispute over which party is responsible for certain repairs could be turned into a dispute over possession, because the landlord might argue that this breach justifies termination of the lease. We think this is exactly what has happened here. The landlords have an interpretation of a specific provision that they say through some further interpretive processes gets us back to the Habendum Clause. But the crux of this case is about the interpretation of certain provisions of the lease. And it's the form of their pleading, not the substance of it, that is creating the argument here about the application of this exception to arbitrability. And
is the problem here that they want too broad of interpretation of the Ohio Arbitration Act, or is it that the Ohio Arbitration Act is unduly broad and maybe the legislature should narrow it in line with what other states have?
No, I think inherent in the structure of the statute, Justice Wine, is this tension between the broad general rule, which has been, adopted many times by this court, acknowledging that the statute evinces a strong public policy in favor of arbitration with this exception. And so when there's sort of this inherent tension there where you have any statute with exceptions to it, and you have to figure out where that line is going to be drawn, and suggest here that the line ought to be drawn along the lines that the courts of appeals have done in a narrower fashion. I don't think that the argument offered by the appellants is, it's their argument is simply another place on the spectrum of where this line gets drawn, Your Honor. And I think respectfully suggest it's in the wrong place on the spectrum because of the basic proposition about statutory interpretation, as well as the point about encouraging creative pleading in order to avoid arbitration clauses.
Mr. Blickensdorfer, if I look at 2711.01 B1, it starts out saying that controversies involving Title II or possession of real estate are not subject to arbitration with the following exceptions. So, but a lease has to do with the possession of real estate. It's not just title. So how do we, and I'm looking at these controversies and I'm not seeing in A through E anything that specifically addresses the situation at issue here. Can you help me?
Yeah, I'll start with the latter part of the question first, Justice Bruner. The parties agree that none of these exceptions apply. The parties agree that none of the exceptions to the exception apply to this dispute. So then, the follow-up question is potentially, what do we make of that? And my answer to that question is, I don't think we can make much of that. No party has argued that we can somehow back in to an interpretation of the exception by looking at the exceptions to the exception. And frankly, I think that would be very difficult. The exceptions to the exception aren't all of a piece. There are several of them that relate to kind of payment or rental type issues, but then there's one involving boundaries. So they don't, in my mind, it's hard to try to back into some interpretation based on the exceptions to the exception. In terms of the basic language of the exception, Justice Bruner, I think it's important that the language says that it doesn't apply to controversies involving the Title II or possession of real estate. So that suggests to me that you can have title or possession issues involved in a lawsuit simply because real estate is involved. They might be indirectly involved, only in theory involved, but we're looking for a controversy that involves that issue. And the controversy here is about the interpretation of certain contract provisions and how they interact with each other. Is it possible to say, take a very broad view of that and say, well, it does involve Title II or possession of real estate because you're fighting about this lease? Yes, that is possible, but I would suggest it's not appropriate because of the pro-arbitration statute, the fairly narrow language of the statutory text itself, and the goal of avoiding situations where parties can avoid arbitration through carefully crafting a pleading to seek the right remedy or to put the right label on the claims. Your Honors, I would like to see, I'm in my last 20 seconds here, and I would just briefly like to say, Your Honor, I think the appellants have waived any argument about the scope as opposed to the enforceability of the arbitration clause, and particularly about their slander of title claim. I do want to apologize to the court and to counsel for a inaccuracy in our brief in which we said they had never raised the scope issue prior to this court, but in fact, they raised it in response to our point in the Court of Appeals that they had already waived the issue. So they have not offered up a proposition of law on either of those points. And so I would just like to suggest to the court that the slander of title claim issues, as well as any issues about the language and scope of the arbitration clause, have been waived. Thank you, Your Honors.
Thank you. Mr. O'Farrell, you have 2 minutes and 40 seconds. You have to unmute yourself, Mr. O'Farrell.
I apologize, Your Honor. Thank you. I'd like to start by saying it's not uncommon that lessors and lessees disagree whether a lease terminated by its express terms. In fact, that was the very case in Brown. It was contested whether or not that oil and gas lease had terminated by its express terms, and evidence would be considered relative to whether or not the lessee in that instance continued to produce oil and gas from the well in paying quantities. Nonetheless, this court determined that the judicial declaration sought by the appellants in Brown was the substantive equivalent to that of a quiet title action. The appellants herein seek the same judicial declaration. As such, it follows that the judicial declaration sought by the appellants in this matter is akin to a quiet title action. Going back to Justice DeWine's
question. Counsel, then why did you call it a quiet title action?
We didn't believe we needed to, Your Honor, because the declaration sought is same in substance to that of a quiet title. The Rudolph versus Viking Resources, which the 4th District held that the declaration sought was akin to a quiet title action, which was affirmed by this court in Brown, said that very thing. But I'd like to go down that road for a minute. Consider this point.
But the allegations between those two causes of action are somewhat different. The result may be the same.
The result is the same, and the declaration prayed for would be the same. And as I said, in Brown, this court determined that such a declaration was equivalent to a quiet title. But again, I'd like to go down that road because under the 7th District's analysis, had the appellants included a claim called quiet title along with their claim for declaratory judgment, the 7th District would have concluded that the quiet title action triggered the statutory exclusion and was therefore not subject to arbitration, but that the declaratory judgment claim failed to trigger that statutory exclusion and therefore was arbitrable. That would result in the trial court retaining jurisdiction over the quiet title action and staying that case pending the declaratory judgment action proceeding through arbitration. Both the quiet title action and the declaratory judgment would be seeking the same relief, but the former would be deemed to constitute a controversy involving Title II or possession of real estate, and the latter would not. I think that example crystallizes and highlights the absurdity that has resulted as a result of the 7th District's failure to recognize the judicial declaration sought by the appellants herein is the same in substance as to a quiet title action. I respectfully request that this court reverse the 7th District, reinstate the trial court, and find that the declaratory judgment sought by the plaintiffs in this matter constitutes a controversy involving Title II or possession of real estate and is therefore excluded from arbitration. Thank you, Your Honors.
Thank you. Thank you, gentlemen. We'll take the matter under advisement and you will be notified of our decision. Marshal, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.